Hello, I'm Katie Broomfield. I'm a researcher in the History Department at Royal Holloway, University of London. In December 2004, the House of Lords gave judgment in an appeal brought by 9 men who had, at that point, been detained at the request of the UK government without trial or charge for almost 3 years. The case became known as the Belmarsh Case, after the prison in which the majority of the men were being held. It arose following an application by the men that their detention without trial was incompatible with their human rights under the European Convention on Human Rights, the ECHR. The ECHR protects the fundamental rights and freedoms which it is commonly agreed are necessary to maintain democratic liberal values and maintain basic human dignity. The convention was drafted in the aftermath of the Second World War, and in March 1951, the United Kingdom was the first of the 47 European nations now signed up to the treaty to ratify it. Until 1998, the only way for citizens in the United Kingdom to enforce their rights under the European Convention of Human Rights, if they were not already enacted in domestic legislation, was to apply to the European Court of Human Rights. However, in 1998, Parliament enacted the Human Rights Act to give effect in UK legislation to the rights and freedoms guaranteed under the European Convention. In circumstances where a court finds that primary legislation, meaning an Act of Parliament, is incompatible with the European Convention, Section 4 of the Human Rights Act 1998 enables the court to make a declaration of incompatibility. Where such a finding is made, Parliament can, if it chooses, legislate to remove the incompatibility. The applicants in this case were all foreign nationals who had been detained under the Anti-Terrorism, Crime and Security Act 2001. This act was introduced by the UK government in response to the deadly terror attacks launched by Al-Qaeda on the United States of America on the 11th of September 2001. Along with the Terrorism Act 2000, the stated purpose of this act was to strengthen the government's powers to deter and prosecute terrorists. Sections 21 and 23 of the Anti-Terrorism, Crime and Security Act allowed the Home Secretary to detain without trial any person who was a foreign national and who it was reasonably believed was an international terrorist and posed a threat to the security of the United Kingdom. It enabled the UK government to detain international suspects even where no crime had actually been committed. The result was that the applicants in this case were not entitled to a criminal trial and thus had no prospect of release. I'm now joined by Dr. David Juricic, a lecturer in law at Royal Holloway, University of London, to find out how the applicants in this case responded to their detention.
Well, Katie, as you've alluded to, the applicants in this case sought a declaration that their detention without trial was incompatible with their rights under the European Convention on Human Rights, specifically Article 5 and Article 14.
What rights are guaranteed by Articles 5 and 14?
Well, Article 5 of the Convention guarantees an individual's right to liberty and security of person, whilst Article 14 states that the rights enjoyed under the Convention should be applied without discrimination. Article 5 is what we call a qualified right. It's not an absolute right. In certain circumstances, it can be legitimately interfered with. For example, if you've been convicted of a criminal offence, or if you are being deported and you're being detained prior to that deportation.
Why weren't the applicants in this case deported?
Well, it's because they were deemed to be at risk of ill treatment if they were returned to their home country. This is where Article 3 of the European Convention comes in. Now, Article 3 is an absolute right. It states that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. Because it's an absolute right, it means that it cannot be limited or interfered with in any way. In the UK, and also by the European Court of Human Rights, it's been interpreted, among other things, to mean that nobody can be deported if they are at risk of being subjected to torture or inhuman or degrading treatment in their home country. And the case law is really quite clear. It says that if a non-national faces the prospect of torture or inhumane treatment if returned to their home country, and if they cannot be deported to a different country instead, and then most importantly, if they've not actually been charged with a criminal offence in the United Kingdom, they cannot be detained, even if they are deemed to generally pose a risk to national security.
So that looks then like a clear breach of Article 5 if no steps were being taken to deport the applicants in this case.
Well, yes, it does, but the government had anticipated that kind of a challenge. So when Parliament passed the Anti-Terrorism Crime and Security Act, the government issued what's called a derogation order, derogating from Article 5 of the Convention and enabling them to detain suspects even when no steps were being taken to deport or charge them.
What exactly is a derogation order?
Well, Article 15 of the Convention allows a member state to depart from its obligations under the Convention in times of war or other public emergencies threatening the life of the nation, although only to the extent strictly required by the situation. The House of Lords, whose law lords were at the time the highest court of the United Kingdom, had to decide whether the terror threat posed to the UK constituted a public emergency threatening the life of the nation, and if it did, whether the measures adopted by the government, which has led to the indefinite detention of the applicants, were proportionate.
What did the House of Lords decide?
By a majority, they weren't in complete agreement. The Lords held that although the terror threat could be described as a public emergency threatening the life of the nation, the steps taken under Section 23 of the Act were not proportionate, and therefore they breached the ECHR.
On what basis did the court hold that the measures were not proportionate?
There are quite a few reasons for this, but the most important one is that the judge highlighted that British citizens who were suspected of terrorism, but not yet charged, were not subject to the same indefinite deprivation of liberty. The legislation breached Article 14 on the basis that it discriminated against the detainees on the grounds of their nationality and their immigration status.
So what order did the judges make?
The judges made what's called a quashing order, which meant that the derogation order no longer had legal effect. They then made a declaration under Section 4 of the Human Rights Act 1998 that Section 23 of the Anti-Terrorism Crime and Security Act was incompatible with the European Convention on Human Rights. The law remains in force at the time, so the effect of a declaration of incompatibility is not to invalidate the legislation. It's instead to signal to Parliament that the UK is in breach of its international obligations and the law should be amended. So, what did this ruling mean for the applicants? Well, the House of Lords were not being asked to order their release from prison, and indeed the Lords didn't have the power to do that anyway in these proceedings. The men stayed in prison until March 2005, when they were brought before what was known as the Special Immigration Appeals Commission, and that commission ordered their release, but with very strict bail conditions. The government had maintained throughout this case that the men detained posed a real threat to the UK's national security, and indeed one of them, Abu Qatada, was later described by the Special Immigration Appeals Commission as a truly dangerous individual. Abu Qatada was deported to Jordan in 2013. However, Lord Hoffman had a slightly different view on the facts of this case. He said the following: "The real threat to the life of the nation, in the sense of a people living in accordance with its traditional laws and political values, comes not from terrorism, but from laws such as these. That is the true measure of what terrorism may achieve. It is for Parliament to decide whether to give the terrorists such a victory." Suspected terrorists are no longer subject to imprisonment without trial. The sections of the Anti-Terrorism Crime and Security Act, which had been declared incompatible with the Human Rights Act in this case, were replaced by Parliament. Firstly, in 2005 by the Prevention of Terrorism Act, which introduced a system of control orders, and more recently that has been superseded by the Terrorism Prevention and Investigation Measures Act 2011. This case was recognised by the law lords as being of particular public importance, reflected in the fact that 9 judges heard the case instead of the more usual 5. Indeed, the civil liberties campaigning organisation Liberty described this case as one of the most important constitutional cases for a lifetime. The men were supported in their appeals by Liberty and by Amnesty International, both organisations which seek to protect and promote civil liberties and human rights. Liberty pointed out that although human rights law does of course require the state to take steps to protect the life of its citizens, and that this would include steps taken to counter terrorism, any such measures must be proportionate and they must respect the individual rights of others in order to safeguard the foundations of a democratic society. Indeed, as Lord Nichols made clear in his judgment, indefinite detention without trial is anathema to any country which is based upon the rule of law.